Hello, everyone. Welcome to Grand Line's online salon. I'm Rama, a communications coach from Grand Line. And together with me is with Miss Florence. Even in the midst of deadly pandemic nowadays, the country is continuously being tormented by the threat of terrorist attacks coming from the Maute group, the Abu Sayyaf group, and the pro-IS Bangsamoro freedom fighters. And yes, as the current administration hinted, also the NPA.
That's why the anti-terror law is such an interesting topic, Ms. Roma. The law seeks to amend and repeal the Human Security Act of 2007 and punish those who will propose, incite, conspire, participate in the planning, training, preparation, and facilitation of a terrorist act, including those who will provide material support to terrorists and recruit members in a terrorist organization. So let's examine some of the details and what makes it very controversial. But first, let us introduce our esteemed guests.
Let us welcome our first guest speaker, Attorney Christy Jane Balino.
Good afternoon, everybody. Thanks for having me again, and I'm looking forward to a very healthy discussion later on.
Thank you, Attorney Jane. It's our pleasure to be joined by our next guest speaker, Dean Jose de la Rama Jr.
Good afternoon, and thank you, Ms. Rona and Ms. Florence. And it's really an honor to be invited in your wonderful show.
Thank you so much, Dean. And let's also welcome our third speaker for today, Attorney Christina Conti.
Afternoon. A pleasure to be here with Attorney Balino, Dean De La Rama, and
Thank
Roma.
you for joining us. Attorney Chrissy, coming from the UP Diliman Emergency Rally.
Yeah.
Glad you made it. Okay, so let's start with the first question. Some groups claim that the new anti-terrorism bill, or now a law, uses an overbroad definition of terrorism that can subject suspects apprehended without a warrant to weeks of detention prior to an appearance before a judge. So, our first question today is some of the most controversial provisions of the law are warrantless arrest, detention of suspects for 14 days plus 10 days extension, so that's a total of 24 days without charge, and the creation of an anti-terrorism council that can label a person a terrorist without the approval of the courts. Do you agree that these provisions are illegal? So maybe we can start with a warrantless arrest and detention for 24 hours without charge. Are these even constitutional? So let's start with Dean Jose de Rama. Would you like to start the discussion?
Thank you very much. To begin with, let me tell everybody that the president, as of yesterday, around 5 o'clock in the afternoon, has signed the controversial anti-terrorism bill. And I'm expecting that maybe by Monday, there will be some groups that will be going to the Supreme Court to file the necessary petition questioning the constitutionality of the controversial law. Now, since it is less than 24 hours old, we are here trying to discuss and explain to the public what the law is all about. Now, regarding your first question, whether warrantless arrest is constitutional and valid, let me begin by saying that warrantless arrest has been in our jurisprudence, in our statute, ever since. Warrantless arrest is covered and sanctioned under Rule 113 of the revised Rules of Court. And as we all know, there are only three instances where warrantless arrest, or what we call citizen's arrest, or before a person can validly arrest an individual. First instance is when the offense is being committed in his presence. And number two is when the offense has just been committed and the arresting officer has personal knowledge that the one who committed it is the person to be arrested. And number three, the last is when he is an escaped prisoner. Now, I would say that under the Rule 113 of the revised Rules of Court, we are giving leeway to the arresting officer or to the private individual the opportunity to examine for himself whether the act of arrest would fall under Article 113 of Rule 113 of the Rules of Court. So, in other words, if the arrest is not in accordance with Rule 113 of the Rules of Court, then we could say that that is what we call an illegal arrest. And once that person is brought for inquest, for example, to the prosecutor's office, chances are the case might be dismissed because the arrest is illegal. So that is the basic concept that I would like to state. So, in other words, that warrantless arrest is not new. Prior to the execution and signing by the president of the new law, as I said, it has been in the Philippine jurisprudence ever since. Now, I would say that after reading the controversial law involving warrantless arrest, now this was carried over under the existing law. And for the benefit of the public, it also gives the opportunity to any arresting officer to detain or arrest anyone who is, number one, let me emphasize, under the controversial law, it has defined act of terrorism, and it falls under from Article 4 up to Article or Section 12 of the controversial law. So those are the things that are covered by anti-terrorism law. Now, as I was looking at the law, it is very important that the purpose and intent or the intention must be clearly established, because a person cannot simply arrest anyone on mere suspicion if the case does not fall within the acts or within the sections provided for from Art sections 4 up to 12, because there is a concrete definition given by law to that effect. So, just like under Article 113, which we allow warrantless arrest, we also allow warrantless arrest provided the provisions of the law are strictly complied with. That is, I'm referring to the new anti-terrorism law. So that is my point on that. So it has been in our jurisprudence, it has been studied by so many lawyers in the Philippines, and I believe that that is sanctioned under the rules of court.
Okay. So in other words, Dean, for you, this is constitutional.
I
This
believe so.
specific provision.
Yes, because
Okay.
the law allows the any officer or any private citizen to arrest or to effect the arrest, provided the guidelines are strictly complied with. If not strictly complied with, then there will be problem with respect to arrest.
Okay. Okay. Thank you, Dean. Now let's move on to Attorney Chrissy. Attorney Chrissy, would you share the same opinion as Dean De La Rama regarding this?
You're talking about Christy Conti. Sorry.
Yes, yes, sorry. Attorney
Okay.
Chrissy, yes.
Well, I would have to disagree. In particular to this section 29, which allows the warrantless arrest and detention of a mere suspect. While I agree that, as the dean said, our law already provides for guidelines and parameters for warrantless arrest. It's the period I have an issue with, the 24 days, 14 days, and if possible, it could be extended up to 10 days. Looking at the Constitution, there is a provision, Section 18, in our Constitution, which, well, of course, first, let's lay this down. Article 3, Section 2 of the Constitution provides for the right of the people to be secure in their persons, houses, effects, from whatever reason, unreasonable searches and seizures, and that no warrant or warrant of arrest, no such warrant or warrant of arrest shall issue except upon probable cause. Okay, let's The dean already discussed a little bit about probable cause. Yes. Now, the thing with Rule 113 is that we have to construe this, we believe, with the Constitution. There are it is circumscribed in section, let me just recall there. Section 18, Article 7 of the Constitution. So it might not exactly be on all fours, but this is the provision about the privilege of the writ of habeas corpus. It says here, it may be suspended in cases of invasion or rebellion or when the public safety requires it. So it seems quite far off. But we note that the suspension, even here, the suspension of the privilege of the writ of habeas corpus uh, is only, even with the suspension of that, the arrested or the detained shall be judicially charged within 3 days. So this is the worst case from what we see. Worst case scenario. There's martial law. The writ of habeas corpus has been suspended. Still, the Constitution says that any person arrested or detained shall be judicially charged within 3 days. Our rules actually state that any person arrested under the revised penal code on light offenses and so forth should be charged within 12, 18, and 36 hours. So within in the context of this provision, okay, fine, the maximum would be 3 days. So the period of 24 days is too much, and we will be going to the Supreme Court on this ground, among our grounds, that this contravenes the Constitution. Uh, just an update to the group of Attorney Howard Calleja, along with um, uh, Dean Luistro, Armin Luistro, Brother Armin Luistro, has already filed through email. This is allowed now by the rules of the Supreme Court. They filed by email, I think earlier today, a petition against it. I have information that there are other groups that will be filing upon the effectivity of the law, which would be about 15 days from yesterday.
Okay. So just to clarify what you said, Attorney Chrissy, it is mostly the period of detention that
Yes,
you
it's
are against.
mhm.
Because
But
from three
I agree.
days, yeah.
Yes, 3 days is the maximum that our constitution allows for anybody to be held without charges. In the Human Security Act, they extended this. That was the period that they put in 72 hours. So it was a little bit less controversial because even without the this ATA, we call it the ATA now. Previously it was the ATB. Now it's
Yes.
the Anti-Terrorism Act. Uh, we have the Human Security Act already. So even the Anti-Terrorism Council exists already as of now.
Okay, thank you for that, Attorney Christy. Now let's hear from Attorney Christy Jane.
Okay, thank you. I think I would be the middleman here because we have the left, the right. I'd be the middle. Uh, as to the question whether the warrantless arrest which is provided under the act is valid, of course it's valid. As Dean said, this is not new. Even citizens, there is such a thing as citizens arrest. But I would have to agree that the period is quite problematic from the standpoint, say, of the counsel of a person who may be held or who may be from the person who will be charged under this law. 24 days is quite a lot of days. I mean, even number of hours to be detained elsewhere would be problematic. So I would have to agree that the period might have been, I don't know what was the I didn't go into the detail of why the 24 days, why 24 to begin with, 14 plus 10 days. But I would have to agree it's quite long considering that even in regular crimes under the revised penal code, even the most serious of crimes, you could only be held for 3 days, correct? So as to the magnitude, say, of a crime, if we consider this as something grave, other crimes in the revised penal code are as grave to me as well, which have been following the same period, which is the 3 day period. So that's my only comment.
Okay, so if not 24 days, let's say 14 days, attorney, what would you say would be a fair number of days for?
Well, I would say they would need to amend a lot of laws. They would need to amend the Constitution. They would need to amend all other laws which provide for the period that I think Attorney Chrissy was talking about. So, what at the end of the day, we're all officers of the court. So, since this is a law, we have to abide by the rule of law. But it has to be read in the. I think it has to harmonize with all the other laws, such as those providing for periods. Remember, when somebody is arrested, you actually have to when a warrantless arrest is effected, you actually have to waive your right to the period before you ask for a preliminary investigation. So there are other matters which have to be considered, which lawyers are quite aware of. So that's my only concern. The 3 days is constitutionally and a lawful period recognized. So I think this has to be read, if not amended, to conform to the existing periods, or vice versa. The existing periods have to be amended in order to conform to this one. So there.
Okay. Thank you for that, Attorney Christine. Now, another controversial part of the law is the creation of the ATC, or the Anti-Terrorism Council. And some are saying that this should be the job of the courts. What is your comment on this, Dean Jose?
Thank you for the question. But before answering that, may I be allowed to say something about the first question?
Yes, Dean, go ahead.
Um, yes, I heard the two lawyers saying that there is some kind of problem with respect to the time frame for the filing of the necessary complaint. But as I was reading the intention of the framers in this regard, I heard one of the authors saying that this anti-terrorism law is somehow sui generis, or a thing of its own. And I heard him saying that in Singapore there is there. I think they have the right to detain from 2 years or indefinite sometimes. And he tried to compare some of the periods in other countries like Malaysia, which they have a longer period. But in the end, they tried to compromise by agreeing that I believe that we can follow the Australian rule and Sri Lankan rule about the 14-day period. So I think it has to be clarified. And we welcome the petition to be filed by lawyers group so that all of us will be enlightened in this regard. But as I was reading the latter portion of the law regarding warrantless arrest, I also read some provisions giving due protection to the person arrested, because within the period, the controversial period of 14 days, the arresting officer must immediately notify the nearest court and also the Commission on Human Rights. And it is up for the court to whether the period of detention will be extended or not. If the court will say no, then the period will no longer be extended. So, in other words, as I was reading it, there are certain guidelines and certain parameters that must be followed, because I believe that the law also protects the Bill of Rights and human rights of every or every citizen. Because I also heard the author saying that it's really hard to build up the case against terrorism or against any terrorist activities. That is why in other countries they allow uh, longer period for that. Now, going back to the second question regarding the creation of the anti-terrorism council, you said that should it be the within the purview or within the power of the court to determine? Actually, it's in the law that the ATC has no judicial or quasi-judicial function, because as I was reading the context of the new law, as I said, this is less than 24 hours old. then the law gives the ATC certain powers or limitation of powers, which is not judicial or quasi-judicial. So, by way of answer to your question, ATC does not perform any judicial function. They are merely administrative body that regulates and to make sure that all the provisions are complied with. They are mandated to make programs. They are required to monitor persons arrested or persons being detained and to determine if there are still programs needed to be complied with by the 9 members of the committee. So that is my view on that.
Okay, thank you for that, Dean. Let's move on to Attorney Chrissy.
So I'd like to put the spotlight on another point about the ATC. So procedurally, I think the ATC, the law may create such a body. I find no big issue as to the creation itself, the procedure of instituting this body. In fact, as I already said, we already have this body. With this law, I think we just added the DICT as part of it because previously we had no Department of Information and Communications Technology. A little bit about that later. But now my problem with the ATC is as regards its functions, its powers, in reference to Section 25. Okay, it's Section 4545 creates the ATC, but Section 2525 gives it the power to designate an individual, groups of persons, or organization as terrorists. Okay, this is a new term. Previously, we only had as a general category suspects or suspected terrorists and prescribed terrorists. Prescribed terrorists, to have that, you have to go to court and ask the court to declare them so. So prescribed meaning on their face, by their membership alone, you can really call them terrorists, and many of the punishments, penalties can be imposed upon them by mere membership. This is judicially determined. But we have an issue with this term designation because it seems to do nothing or have no real effect, save for designation is actually labeling. And by extension, in context, it is akin to red tagging. Just calling people, oh, you're a terrorist. Supposedly, you can designate persons based on probable cause. Now, probable cause is a legal term. And through it's not just the courts who can determine probable cause. We can also have executive determination of probable cause through the prosecutor. So the prosecutor is not a judge. He's a lawyer, yes, but he's a lawyer of the government. So the public prosecutor, under regular or usual cases, they determine probable cause. So as it seems, it is the duty of the looks like as it because we don't know really what designation is because what are the effects of designation it's not really clear. It's just another category. It's like you're being labeled on your forehead. I'm a designated terrorist, but what does it really mean? Anyway, this probable cause will be determined by the Anti-Terrorism Council. Now, we don't know how they will determine probable cause. In cases where the public prosecutor will determine probable cause, there's a lot of jurisprudence. We already know how they should do it. They hold hearings, they look at the documents, they ask for evidence. But how about here? How will the ATC determine probable cause? There's nothing, no clarity as to it. We can sort of extend our in terms of analogous situations, but we're not really sure. Will the ATC hold a hearing before they designate someone, or can they just simply declare, "Oh, you're a designated terrorist already"? So, as to this power in particular, it's a broad power, and to an extent, it could be a conflicting power because what's the difference between designation and prescription? Prescription being the province of the courts. So with that, the power of the ATC, its creation and giving it the power to designate terrorists should be declared unconstitutional for violating due process.
Okay, thank you for that, Attorney Chrissy. Okay, let's go to Attorney Christy Jane before we
Um,
go on to the second question.
as to the question whether the ATC is it correct? Is it legal or is it constitutional?
Or is that something that is in the purview of the courts, supposedly?
As mentioned by Attorney Chrissy, actually, it's not a new thing. The ATC has been consistent since the Human Security Act of 2007. That's one. Secondly, in the new law, there was the addition of, aside from the DICT, which was already mentioned, the AMLAC is also a member. I think, according to the provisions provided for, it is not a court. That's one. It does not exercise judicial function. It does not issue uh, search warrants. It does not issue orders of arrest. So, strictly speaking, it does not exercise judicial function. Whether exercise of the determination of a probable cause encroaches upon the judicial functions, we have to consider, as mentioned already, prosecutors also determine probable cause being simply existence of facts that would engender a mind to believe that something was actually done. The designation per se does not lead to an arrest. I think that's, if I'm not mistaken, that's very clear. But I have to agree that the designation was not included in the definition of terms as to what exactly is a designation or what does it do. I think it would have been better if the law provided for a definition, because when you designate something, what's the effect? But I do understand from the point of view of the law enforcement or the rationale behind the law that when you designate something, when you designate an organization, an individual as having been engaged in terrorist activities, the effect would be, since AMLAC is a member of the ATC, now they could actually look into the finances. I see the wisdom in that. But I do understand that the problem would lie in the actual interpretation of certain law enforcement agents, perhaps, and the actual interpretation of the members of the council, which, well, since it's a new law, it just came out yesterday. I guess this would all have to be clarified and defined clearly, or more clearer in its implementing rules, I believe, since there has to be implementing rules that would come out in order to give us more understanding of the actual terms that are used here. Misinformation would cause more harm, actually. So I think that's the standpoint of a lot of Filipinos, and that's the concern of a lot of Filipinos. When you use terms such as designation, which haven't really appeared in any of our laws to begin with, or even in the revised penal code, there's no such crime as designation, or there's no such act or judicial act as designation. The problem would be on the qualification of certain terms. I think since we are a government of men, government of laws, we have to abide by certain definitions. So we have to define. If it's not defined, then the court would have to strike it down for being ambiguous, being vague, or not being understandable to the layman. So that's my comment.
So it's clear that the ATC is not a court, or it's not trying to function as one. But it's also clear that there needs to be more specific or more or guidelines in which they operate that has to be clarified. All right, so thank you so much, Dean Jose, Attorney Christy Jane, and Attorney Christy, for all your input. I'll pass you on now to Miss Roma for the second question.
Thank you so much, Ms. Florence. Now for our second question. What worries activists the most about the anti-terror law is the chilling effect caused by the inclusion of new crimes, something that they fear can be abused and wielded against ordinary people who complain about the government. These are the new crimes: proposal to commit terrorism under sections 3, G, and 8, threat to commit terrorism under section 5, planning, training, preparing, and facilitating the commission of terrorism under section 6, inciting to commit terrorism under Section 9, and recruitment to and membership in a terrorist organization under Section 10. Another important change is that Section 16 seeks to expand the list of persons who may be subjected to surveillance or wiretapping. The definition of surveillance activities include the tracking of individuals and not just members of organizations declared by the courts as terrorists. Now, our second question is, will the anti-terror law broad definition of terrorism really lead to abuse, and do you agree that that may be used to weaponize the law against critics of the government?
Um, to be honest, it doesn't have to be the anti-terror law. You can weaponize whatever law you want to do as long as the people in power would use it. That's I think a premise that we use. But since this is a new law, when you say you weaponize it, you have to ask who will first use it. And I do understand the concerns of groups regarding the probability of this law being used. But at the end of the day, all those who are in government are not forever there. That's one. And number two, you can't really say that it can be used as a weapon because just like anything, there are pros and cons. We have to remember that this law had to, no, not this law, but there were several instances that terrorist groups or there were certain terrorist acts that resulted in a number of killings, a number of families that have gone, a number of family members that have gone. So from their perspective, I think this law is what do you call this? Is what we need. But and to be used as a weapon, yes, towards the terrorist groups. But as to whether it could be used by the administration, it actually really depends because this law is not just by one person. There are certain factors here, and we have to remember that this law also provides for penal violations for its violators. For example, a law enforcement agent wrongfully arrested somebody over using this law. There would be a threat of penalty of imprisonment for 10 years for a police or a law enforcement agent or a military personnel who would fail to provide who would fail to notify judges and all the other parameters for when you arrest someone or when you detain someone without charge under this law. The so that's my comment on that. While this law, as controversial as it is, it can be used as a weapon by both sides. It could be used as a weapon against terrorist groups. It could be used in the wrong hands or in the wrong people in the administration, perhaps. But we are really not in a position to say at this point that it could be because there are still no implementing rules. We don't know yet how it's going to be implemented or the agencies. So I think we have to hold our thoughts to this and see what's going to happen next. As to the second question, or what is it? The other question?
Um, do you agree that? Yeah, I guess that's the question. That's the only question that could be used to weaponize the law against the critics of the government.
What about the chilling effect? Was there a question?
What worries activists the most about the anti-terror law is the chilling effect caused by the inclusion of new crimes.
Okay. This is a law, and we still are governed by law. So at the end of the day, before you are arrested, due process would still apply. So it does have a chilling effect. I've seen people and groups on social media saying, and there are also posts saying that you should take down your anti-government posts as early as this time. I do understand that, but again, we have to, I guess, read the whole law first and then look at its parameters. You can't just be arrested. That's the we're lawyers. We're still bound by the rule of law. But at the end of the day, we are still if we exercise our freedom of expression, which is what we are exercising whenever we say anything against or for the government. The only thing is that we have to read the definition of the terroristic acts or the definition of terrorism under the law. You only have to worry if you fall under those kinds of terms. That's my. If your statement falls, I don't think it. For example, a Facebook post, I don't think it would fall necessarily under this law, but there are other definitions. And also, we have to remember that the purpose of this law is against terrorism. But also in its, I think in its declaration, it also upholds constitutional principles, and it does not disregard that. That's why it provided for severe penalty as well for those in the law enforcement who may take advantage. So there.
Okay, thank you so much, Miss Christy Jane. How about Attorney Christy Conti?
Yes, thanks. Um, First, the concept of chilling effect applies to provisions or laws which have an effect on the freedom of speech, because that's where really you can appreciate a chilling effect if you're going to speak and going to be subsequently punished, then you don't speak at all. So that's where you find the chilling effect. And that's right. You have all these people online. We're feeding it now. You have all these people online thinking of or saying things like, should I delete my Facebook account entirely? Should I delete all my Twitter history, etc.? That is precisely what is the chilling effect. People will no longer speak or talk about, particularly political, economic, social circumstances in the Philippines, which is what's written in the law. Because one part or one aspect of terrorism, how you can affect it is by destabilizing or destroying the fundamental political, economic, or social structures of the country. So if someone says, "Oh, would I be destabilizing or destroying the fundamental political, etc., etc., by saying that this government sucks in any way, if you think that, oh, maybe I will be leading towards the destabilizing, etc., and you no longer speak at all, that is already a chilling that chilling effect. So with all these crimes, I think what would be most easy to 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 appreciate within that context would be the crime of inciting to sedition. You have all these other crimes through. We could go on about these proposals, threat to commit terrorism. And just on that note, I think these were included by the legislators to also, uh, penalize the preparation. So preparatory to the commission of the crime, you can already um, punish or penalize or charge people. Previously kasi under the Human Security Act, people had this, well, the law enforcement agents thought that they could only um, hail people to court after they have already bombed, after they have already killed, after them, so and so forth. So these preparatory acts, they said, should also be included. Now, but I have an issue with this inciting to commit terrorism. It's similar to the crime of inciting to sedition. Inciting means to encourage. I'm not sure if everybody is familiar here with the case of the teacher. Kaya. So let me expound a bit. This is a teacher who posted on Facebook that he was giving a 20 million bounty to anyone who would kill Duterte. Uh, Sedition is also covers that. The threat or the killing of any government officials such as the president, vice president. So it fell within the context of inciting to sedition. But it was it was just in the context of a joke. It was even exasperation on the part of his teacher. And nobody took it for real, except for the policemen. So yes, I agree. It will largely really depend. The abuse that we will be envisioning will come from what kind of law enforcement officials are going to enforce or to implement this law. If these are the kinds of people implementers who will do that, who will also implement APA, these people who thought that harmless Twitter or was it a Facebook post of the teacher was inciting to sedition, then we'll all be having cases in court. And then the thing is, the problem with that is actually if you have an overbroad, okay, so if I'm overbroad or a vague law, The problem is you will be putting an onus on the law enforcer, the policeman, or actually in the under the ATA, even the AFP, even the military might have a larger role in this because this is anti-insurgency. Um, will they be at liberty to determine? Will they have the arbitrariness to determine, oh, this person committed inciting to sedition by posting this post or by posting this picture? And if we say yes to that, then this law is broad. We will be arguing in our petitions which provisions exactly are vague, which exactly are broad. But to give an example, uh, there's this term public safety that's put in here that's put in here the definition, engaging in acts intended to cause interference with critical infrastructure. It is defined, but we have questions regarding this. As regards incitement, okay. Um, with regards incitement, so it's anything that encourages. So we're asking, how about advocacy? Oh, the law says, oh, no, no, let's not put that in. But how about academic discussion? How about theory? How about debate? How about, in a sense, glorification of terrorism? Talking about previous terroristic acts. That's already done. But you're just saying, good thing or buti pa sila. They already achieved this. Nagawa nila ito. Would that be considered inciting to terrorism? Will it in any way encourage others to commit terrorist crimes today? And on the last point, I don't think all, I don't think anybody actually agrees or um, supports terrorism. Uh, Even if you are anti this anti-terrorism bill, you are calling for the junking of the terrorism law. It doesn't mean that you are pro-terrorism. In fact, we are one of the groups, where the Concerned Lawyers for Civil Liberties, who are standing strongly against terrorism, which also includes state terrorism. And it might be curious for all of us to look into the sponsorship speeches, and rather the explanation of the votes of those Mindanaoan politicians, legislators who have been who are facing terrorism every day. And I really appreciated how they framed their discussions, how they framed why they voted no. They tell us we are the ones who face terrorism, but this law doesn't really look like a law that will protect us from it. So with that, uh, I do think that the chilling effect will not only be against terrorists, because clearly you want a law that will frighten the terrorists, where they will be scared to commit these crimes. But I don't want a law that will also scare me, a regular citizen, calling upon the government to do their job.
Exactly. Thank you so much, attorney. And just one last question, just a follow-up question. So, on top of this, law enforcers who mistakenly arrest someone for terrorism will now be required to pay damages for the wrongful arrest. Would you think this is a rightful one? Maybe we can have Dean Jose for this one.
Hello.
Yeah,
Yeah.
yes, Dean.
Yeah, it's good that Attorney Creasy raised the case of that teacher who happens to be from my region. I believe he's a teacher from Zambales, and being the former governor of Central Luzon, it saddens me that when I learned that the poor teacher, as Attorney Creasy said, he was only trying to make a joke, right? So that's why some police authorities took it seriously, and he was charged of a certain offense. If the anti-terrorism law, it's good that Judge Pradera of RTC Olongapo dismissed the case. So I believe that this is a classic example. If he was arrested at the time anti-terrorism law was already in effect, those are the safeguards under the law, because as you can see, there is a due process being under our procedure, and it so happened that he was charged of a certain offense, but ultimately, upon the determination of probable cause, which is also guaranteed by our criminal procedure, the Honorable Court found that there is no basis for the charge because it was not intended. As I said, if the anti-terrorism law is already effective at the time, there is a provision under the law when by the nature and context. So let's not forget those words. The nature and context, the intention of the person is really important. Attorney Christie said that maybe the teacher was only trying to make a joke. So did it create fear to the people? No, it did not. Maybe he was trying to impress. When he was arrested, I overheard him saying that nobody was trying. He was only trying to make a joke, and he would like to be known to the public. So in other words, the intention of that teacher is not to create or to perform any act of terrorism as defined from Section 4 up to Section 12. So those are the guidelines that I can see, and those are the safeguards that I can see. Because regarding your question, is that considered a chilling effect? No. I believe that the act of terrorism are well defined from sections 4 up to 12, and there is another colatilia. It's not enough that your actuation falls under section 4 up to 12, but there must be an intention by nature and context. Your intention is really to commit any act of terrorism. So that's the only time that you can be charged, because we all agree, Attorney Christie and Attorney Christie, we all agree that for peace-loving citizens, nobody would dare to love terrorism, because we do not know how terrorism works. We do not know when will it strike, because like what happened to Marawi and like what happened to America, like 9/11, or even the most powerful nation was attacked by terrorists. So we do not even know how they plan. Maybe their manner of planning is well far advanced from what we know, or maybe I would say that the acts as defined from sections 4 up to 12 might not be enough, or might not cover other forms of terrorism. Because as far as we know, these at present, these are the acts of terrorism as defined by our Congress, which was recently signed by the President. Another point is with respect to freedom of expression. Uh, I do not agree that simply because you tried to criticize the president, or simply because you tried to make some announcement, dissatisfaction against the government, you can already be charged. And as the result, you will already shut your mouth and you will not make any more noise about that. No, I believe that the Bill of Rights, especially the freedom of expression, is also well protected under this law, because if your intention by nature and context of your actuation, you are not performing any act of terrorism, there is nothing to worry about. But if you are a peace-loving citizen and you abhor terrorism, then there is nothing to worry about. And that is the I think that is the reason why there is a council. I overheard uh, the two beautiful ladies saying that there is no clear definition as to the function of the council, because there are some lacking matters. Well, I agree with the two beautiful ladies here, but I think that is one of the functions of the council, that is to define, that is to make programs, and that is to monitor, because there is no implementing rules yet, attorney. There is no implementing rules yet on this regard. So, since this is only less than 24 years old, we do not know if there is already an implementing rules, but there is a proper time frame for that. So, I believe that taken collectively, I fully respect the apprehension of some groups. I think IBP is also trying to file a petition soon. I'm also part of the Board of Governors before. I overheard our national president, Attorney Egon Cayosa, that the group will be filing the proper petition. And we welcome that because that is the nature of due process. If there are some matters which are unclear, then let the Supreme Court decide. So if the Supreme Court will decide that some of the provisions are void, then we welcome those changes because we can see that democracy and justice in our system is alive, and the Supreme Court will not sleep on their bed, and they will not allow that civil liberties will be trampled upon by the government if proven that this anti-terrorism law is really against the law.
Wow, thank you so much, Dean, for that clarifications and very clear explanations. I guess we have more discussions coming with Ms. Flo with the third question.
Very interesting discussion. I'm learning a lot, Mr. Ma. I think a lot of things have been clarified about this law. For our third question, give me a second here. Okay, so knowing that we are in the middle of a pandemic and that we are facing a health and economic crisis, is the timing of the passage of the anti-terrorism bill now signed as a law questionable, or is there something about the timing of this, as most people or as most critics have noticed? Let's start with Attorney Christie.
Well, I am of two minds about this because first, yes, of course, it's fishy for this bill for this law to be signed now when the enemy or the biggest problem now would be COVID-19. It's really funny how well we've not even flattened the curve, which was the rallying cry for about three months now. Now they tell us, oh no, that there's a different enemy. But we've heard Duterte harping on the NPA and as a terrorist group as the number one enemy, which really threw so many people off balance because why are we in quarantine? Because of the NPA or because of the virus? So because of the conflicting messages, because of the actually it's not in a sense conflicting, it's just too many messages or the overwhelming amount of information that we all have to process during this pandemic has been so stressful. So the question of implementing this anti-terrorism law must also be taken in the context of overall Duterte's political positions and political stance. Actually, he's been very hard against the NPA and quote unquote the communists, the left, ever since. Well, yes, he did welcome peace talks with the left in 2016 and up to early 2017. But after that, he's been so hard on them. So, in terms of, we didn't, was this out of the blue? No, really. It was always there looming that he was going to sign or he was going to make some sort of law or some sort of legal framework that will go after the NPA, the communists, and their legal fronts. And this just really came not out of the blue, but came so frustratingly on the back or on the tail end. Actually, I don't call this a tail end. We're actually at the peak of the pandemic, of the problem. So, yeah, I believe it. The effect of this is that our government will be looking at so many fronts. So they have the front, the COVID-19 front, the health crisis and economic crisis, and now they're going to have this anti-terrorism front. So where do we go? What do we do? And this really stresses a lot of people because, from for example, from the perspective of uh, the GP drivers, what they want is aid. What they want is food. What they want is livelihood. And now you're telling us you're going after the NPAs. Where are they? I mean, in some urban areas, they don't have NPAs there, so they're not so much aware of the problem there. So I think this will have a backlash actually with government It will really rile a lot of people. It will raise a lot of distrust. And even among, uh, you know, to say it, lower classes are already frustrated with the government. They haven't been getting aid during the pandemic. And now we're having the middle class and even the um, uh, upper middle class and onwards going against the president because of this anti-terrorism bill. It's really a broad front. And sorry, but I'm so happy to see a broad variety of people going against this bill. This has been one of the most historic circumstances where, it's not just the activists, it's not just the common opposition who's going against it. You have the church, you have rich people, you have businessmen going against that.
Okay. Thank you, Attorney Christy. Now let's hear from Attorney Christy Jane.
Okay, thank you for that question. First, we have to categorize. I speak. We have to understand that national security is not a single aspect thing. Remember that there are political threats, there are economic threats, there are cyber threats right now. So, was this a bill that turned into a law yesterday, fast track? We maybe there are certain comments, but we're lawyers, so if in court you are asked the same question, you would answer, "I am incompetent to answer because I was not the one who did that. I was not a member of the Congress." So, was the timing questionable perhaps to some because there are other priorities that should have been there are other matters that should have been prioritized. But I have to say this because terrorism is not a new priority. The threat to the national security has always been existent since then. So if an administration um, focuses on one aspect of a threat to national security, which is this one, say the domestic forces or the insurgency, so on and so forth, then I think we have to acknowledge the government's effort to quell certain aspects or threats. Whether this has been prioritized over the pandemic issue is another matter, actually. I could understand, and I also agree with Attorney Christie that there has been civil unrest in the lower class, in the middle class, anywhere, because not just people, not just the rich, not just the poor, but the rich have been affected. Remember, there had been several closures of businesses, but the threat or the enemy of or the terrorist being the enemy is not new. This has been existent since day one. In fact, civil unrest is also a threat to national security. So I think we have to understand that the efforts of the government in order to may have been what do you call this? It depends on the perspective. Okay, so I do think that this I cannot say that it was fast track because for everybody's information in the Philippines, for our foreign viewers, before a bill becomes a law, it's quite a tedious process. Okay, so it has to start from the lower house or the Senate or the Congress, and then it has to undergo 3 readings on 3 separate days. So it's not an overnight thing. That's one. When you say fast track, I don't think it could happen overnight. And remember that those that are sitting in our legislature are elected by the people. So basically, we as their constituents put them there. So on that note, there had already been prior safeguards. I mean, to think about it, since we are represented by our elected representatives, they should look out for our best interest. So fast tracking should, I think, is not something easy to do. Uh, and again, I have to what do you call this? I just have to recognize also the government's efforts in addressing everything. The pandemic is something abnormal. When you say that this has taken priority over something, there was no precedence before. We can't really say that this government did that because we cannot please everybody for one. While there are efforts, maybe there had been problems in implementation. And also, the anti-terror law was not the only law passed. There were other laws. So if we were to say that this was fast track, then we have to look at other laws that have also been passed. So it's I think the sensitivities at this time are very heightened because we are all affected, whether you're from the lower class, middle class, upper class. But strictly speaking, I don't think that we have evidence to suggest that this was fast tracked simply because the procedures in making a bill into a law is not that easy. So there.
Okay, thank you, Attorney Christine. Now let's hear from Dean. Jose.
Yeah, as I was saying, I really admire the view of the two beautiful ladies in front of us, and I really appreciate their views and concept relative to this program. Now, the on my part, the act of prioritizing which bill will answer the needs of the country, or what particular law should be acted upon, which is already pending in the House of Representatives or Senate. I think the president has the prerogative to at least advise, or to at least notify the Congress, both chambers, if possible, this particular law, which is pending in their chambers, would be given priority. This power, or this function of the president, of course, since he is the president, he knows what are the priorities needed. He can request the Congress to prioritize the particular bill. Now, my take on this regard is that first of all, terrorism. We do not know when terrorism will strike in our country. We do not know what will be the outcome or extent of terrorism if not acted upon immediately. Now, in the bill, if you will notice, there is what we call weapon of mass destruction. I do not want to listen to some chismis, or I do not want to listen to some theories about the present COVID 19. But I heard that all of us know that there is, I think there is one group saying that this is a biological warfare committed by one country against the entire world. I do not know, and I do not have any personal knowledge about that. Now, thinking ahead or thinking outside the box, if this COVID pandemic, which affected the entire world, or the entire countries in the world, is actually a weapon of mass destruction, which I think is embodied also in the anti-terrorism bill. And if this COVID pandemic will be classified after compliance and after evaluation by the council and the court, for example, will be proven to be a weapon of mass destruction, then these unseen things which we are suffering, that has affected millions of people worldwide, can also be classified as an act of terrorism. So that is my point of that. When we talk about terrorism, let us not concentrate on violence. Let us not simply concentrate on bombing, or let us not concentrate on any or causing death or serious physical injury, or any act that will destroy or destabilize the government. It could be also in other forms, like bioterrorism, for example. This is one form of terrorism which must be addressed by the nation or by the country as a whole. We all know how we have seen how the people suffered. And if it is true, again, I do not have any evidence. If it is true that this is a form of terrorism, then there is really a need to prioritize this bill in order for us to combat this unseen terrorism which is happening now in our country.
Okay, that's a good point, Dean. Unfortunately, we are running out of time, but it has been a great discussion, and all your opinions and everything you said They're all, I think, very informative, and I'm sure our audience have learned a lot from this session. So let us now move on to the next part of our program, which is the question and answer from our Facebook audience. So I believe we have some questions here. I'll pass you on to Miss Roma.
Thank you so much, Ms. Florence. So we have some questions here from our viewers in Facebook. So the first question here, so any of the guests can answer. So the first question from our Facebook viewer is that the Anti-Money Laundering Council said that this ATV will boost our credit rating and will prevent the Philippines from joining the list of countries considered as risky in the international financial system. Is this true? Who would like to answer first?
Let's give the floor to Attorney Chrissy.
Okay, Attorney Chrissy.
Well, as Attorney Balino earlier said, I might not be in the best position to state that. But take note that this is hypothetical situation. If the reader or the one who asked the question has particular evidence with regard to the credit rating ranking, then fine. Perhaps we should believe that this is not our expertise. It's not a legal matter.
Well, personally, if I may say, again, I'm not in a position also to make any comment regarding that. But what I heard are rumors, and I hate to state rumors, especially there are so many people listening to your program. But for every particular country, there is what we call threat assessment. The United Nations will also try to monitor how a particular country makes a program to combat terrorism, and there is a particular sanction if we fail to comply or at least perform or do programs that will counteract terrorism. Really do not know how it will affect the AMLA thing that the viewer is asking. But I think somewhere it has something to do with it.
Okay, just to give my own opinion, in my little knowledge of how the AMLAC works, there is a what do you call this? There are certain countries that are blacklisted, for example, for failing to enact certain laws such as the AMLAC. So I believe the FATCA requirements and all those things that you hear, which are foreign to us lawyers, if not engaged in that field. Will this law boost our rating? Perhaps, because from a layman's point of view, a country that is safe is a country that is best to invest in. So, if you know that there are laws in place in a country where, say, you're a foreign investor and you wanted to invest in a country that has a lot of peace and order situation, or that has a lot of peace and order problems, then I don't think you'd go for it. But if there is a law, albeit very controversial one, which aims to cut or nip terrorism at its bud, and you are an investor looking at developing something in a country, I think it would make you think twice and make you or perhaps motivate you into going into that country. But I also agree with Attorney Chrissy that we have to look at credit rating or rankings first before we could actually say, and since this is a new law, it would be prudent to look at the ratings last year and then see if this law is not struck down in its entirety, if it actually helped our ranking as a country.
Absolutely. Thank you so much, attorneys. Attorney Chrissy, and Dean. And we have another question here. Is it true if for example, if I export chemicals from another country, like cleaning chemicals, let's say, for a certain purpose, can that be considered biological weapon according to Section 3F of Anti-Terrorism law?
Well, under the law, but not per se, it's not, because that things or that those items must be used for the purpose of promoting terrorism. If not, then it is you will not be charged and you will not be violating the law. Just like in my earlier example, simply criticizing the government or the president, it's not an act of terrorism as defined in this law. Because your intention, just like the teacher, he was only trying to make a joke, then based on the elements of anti-terrorism law, his actuation does not fall within any of the provisions from sections 14, so from 12. That is why his case was dismissed.
Okay, thank you. One last question. We have still one last question here, and I guess this is for Dean. What's the specific salient point of the anti-terror law that would have a chilling effect on fundamental liberties? Can this law be attacked on its face?
Well, I agree with the two beautiful ladies regarding the time frame when the person being detained there, because under the present law, the person can be detained within a period of 14 days, or
Yes.
it can be extended for a maximum period of another 10 days. And we all know that there is a constitutional safeguard, as the two beautiful ladies said. You should not be detained longer than the allowed period provided for by law. So probably, if you will ask me personally, probably it must be clarified. If the lawyers group will be filing the proper petition in court, then it should be clarified. The only justification that I heard from the author is that this thing is sui generis. To my mind, it also brings question to me because we were taught in law school that anything beyond or anything not in accordance with the Constitution is is unconstitutional. So probably it would send a chilling effect to the people because there is a great disparity of the period from the normal period that we know. Now we will be shifting to another period, which is 14 days, in accordance with the new law. Then it must be reconciled, and there must be a court ruling to that effect.
Ms. Roma, I think Attorney Chrissy Conti would like to say something about the first question as well.
Yeah,
Attorney,
sorry.
maybe we can give you 30 seconds because we are running out of time.
Assuming that the question was because he or she is involved in the cleaning business, then I agree. We really have to qualify. But then there's 2 points about being charged. First is it's a different thing to be convicted or to be proven guilty of this crime. It's another thing to be charged. You can be taken into custody because, for example, your cleaning materials were alleged or somebody tipped to the police that it is going to be used for something that is disastrous to the economy. You could be charged, but eventually you might be acquitted. But it's a different thing entirely to be charged, to be suspected of, to be already given sanctions. So that's the problem with that situation.
Okay.
Okay,
Yes, Ms. Roma.
okay, so that's it. I guess that's all we have for the Facebook questions from our viewers. Thank you so much to our guests for answering clearly all the questions from our viewers. Now, proceeding to the next part of our program. The next part will be the final messages from before the final messages, I should say. I'll be giving you first vocabularies that we will be learning and we will be sharing to you some helpful words to expand our vocabulary. So the first one is warrantless. This is an adjective which means something is carried out without legal or official authorization. And now the second one is amend, which is a verb to make minor changes in a text in order to make it fair, more accurate, and more up to date. And the last one is repeal. This is a verb, the removal or reversal of a law, the act of taking something back. So we have three here: a warrantless, amend, and repeal. So that's it for our vocabulary. Now, for the next part of our program, will be the final messages from our guests and from my host. So let's start with our first guest, Miss. Let's have Attorney Christine Jane Balino for the final message.
All right. First of all, I would like to thank Grandline again for inviting me and for having me today in this discussion. This is a very controversial issue. That's why I said earlier, sensitivities are very heightened because if you're from the side of the law enforcement, you might take this as something that is a blessing already. If you are coming from the families of those who have been affected by terrorist attacks before, you welcome this as something good. But say if you are from the side of those who have been charged before wrongly, who have been arrested wrongly, or even stereotyped for that matter. Just to give everybody a context, I'm from Mindanao as well. So I have and Cotabato City at present. So I'm quite privy to whatever is the local situation. But I'm also connected with several in the by profession in the law enforcement. That's why I understand where everybody is coming from. My final message would be their apprehensions of the people, say chilling effect, say it's quite void. All these are very welcome as we are governed by laws, or as we are under a rule of law. We know that since this is a law, it's either the Congress by legislative action, by repealing it or amending certain provisions of it, or by the judiciary and striking the provisions down as unconstitutional, would we have, or would we be able to get the change we want? Apart from it, while there are so many things going on, the pandemic, pandemic here and there, and then the economic crisis going on, I think the purpose of the law really is to to end terrorism if possible, if not at its inception, to stop it, which was, I think, the purpose in having the HSA of 2007 amended. Because you can't have something already done, especially if it's terrorism. You can't really wait for something to be bombed before you act on it. I think that's a good purpose of the law. So my only message would be for the people to be, apart from being vigilant, for the people to read more and understand more. We have heard from my co-guest here, Attorney Chrissy, that there will be petitions filed on, and from the ID as well, from Dean Delarama. These are all welcome petitions. All we need is a better understanding of the law. So if we don't read, if we just act on it, perhaps misinformation might be more dangerous than this actual law. That's misinformation and misunderstanding. And I say this not just to the audience. The audience would be not just to our listeners, I mean, but also to the law enforcement agents who are also members of our populace. I think everyone, even the law enforcement agents who will be implementing this law, should read more about it and understand what actually is the law that they're trying to implement. At the end of the day, good or bad, a law boils down to the implementation and how it should be carried out. If there are indeed abuses to this law, there are legal options to that, which was already seen in the situation of the teacher, which was actually released. So we know that the law is working, that due process is here. And lastly, I would want to say that I hope everyone is safe at this present time. This is a pandemic, yes, and we have all the controversial issues going on. But first and foremost, I wish everyone a good health and to continue doing the things that they are doing in order to stay healthy. Thank you to my students, to my family members who are tuning in, to my friends who are tuning in, to Grandline for inviting me, and to the staff of Grandline for doing a great job in organizing this. So there. Thank you.
Thank you so much, Attorney Christy. Now let's also have Dean Jose de la Rama.
Well, thank you. I feel so honored to be invited here together with the two beautiful ladies in front of me. And I'm extending my invitation to these beautiful ladies to teach in the TSU School of Law because of their intelligence, wit, and wisdom. So I'm extending my invitation to both of you. Well, as I said, as we were trying to discuss, this is a healthy discussion among ourselves. And we only have one intention, and that is to stop and eradicate, if not to totally get away with terrorism. Because to me, terrorism is the most malignant scourge that mankind that must not only be abolished, but it must be stopped at all costs. So, in trying to eradicate terrorism, which can struck any country or any Filipino people anytime, we have to be very vigilant in fighting terrorism. The government alone or military, where I belong also, cannot do it alone because we need the intelligence coming from the citizens. Because if the citizens will not participate in any act of terrorism, the government would be helpless in performing its main function. As I said, as a lawyer, we are made to believe that this anti-terrorism law is supposed to protect the personal liberty, the security, and the national security of every nation. And if proven that this anti-terrorism bill will be uh, will be violating the fundamental civil liberties and will be violating the basic provisions and Bill of Rights of every citizen, we as lawyers will not hesitate to raise our arms and go to court in order to join our brethren in uh, fighting so that there will be a better and safer Philippines. Good afternoon, everybody.
Thank you so much, Dean. Now let's also have Attorney Chrissy Conti.
Well, just briefly, I would just like to thank Grand Line and of course Flo for inviting me. This is actually because of the circumstances from last night's signing. This is my like fourth opportunity or fourth time to explain to a different audience the Anti-Terrorism Act. So, and I like it that I can jog my mind into um, trying to figure out how the audience can appreciate or understand the Anti-Terrorism Act. We're lawyers and we're looking at this through the lens of the law, all these words and documents. But when you really go out and ask the people what they understand of the law, it's a different thing. So for us lawyers, it's really a challenge how the regular Juan de la Cruz, the regular Filipino person will understand and thinks about this law. It's also important because on the matter of injury and on standing, how how a regular Filipino will go to the Supreme Court challenging this petition. True, it's about the legalities. True, it's about what you learn in law school. But at the end of it all, at the end of the day, the Supreme Court will ask the petitioners who will go to them, what's your standing? How have you been injured by this law? Why will this law be contrary to your interests? So today I've talked with youth. I've talked to, I think I went on an Australian Filipino radio, and the questions and the range of the discussion has been really, really exciting. And no offense, Dean, but what I found really beautiful about this has been the discussion, the thoughts that have been exchanged. And if we focus on that, really, the Anti-Terrorism Act is something that we all have to face sooner or later. It's law already, and it will be effective about by July 19th. It has an effect on everybody, not just the terrorists. As I've said, because of our argument that this is overbroad, uh, even those who are not terrorists might run the risk of being prosecuted. Even up just to that point, prosecuted, even if they're not going to be convicted, they're prosecuted. Or if we backtrack a little, even just suspected. Any communication, any relation, any, you know, act or if we were to think of this as a virus, any contact with a possible suspected designated terrorist is going to be a big issue in the future. So, are we going to run around avoiding all the possible terrorists? And in the first place, who are these possible terrorists? Who are these people that we should keep an eye on? Are these the people from, sorry to cite school, UP? Uh, because they call graduates from UP the activists, the progressives. It's a leftist school. It's producing all these communists in the country. Are we going to avoid all those who are voicing criticism against the people? Are we going to avoid anarchists who are just, going around and saying, no, we just shut down this government, but are not actually capable of shutting this government down? So, if we look at it as if it's a pandemic or a virus, who are the enemy? And remember the adage, one man's terrorist is another man's freedom fighter. So with that, thank you again.
Thank you so much, Attorney Chrissy. And now let's also have Miss Florence.
Yes, so thank you very much to all of our guests today, to Dean Jose or Dean Peng. Sir, thank you so much.
You?
Attorney Jane, I know you're very busy and this is already your second time to guest with us. Thank you so much. You have a fans club here now. And of course, Attorney Chrissy Conti. Thank you so much, Chrissy, for I know you have so many media engagements. You're all over on TV and
Hey,
newspapers everywhere, but
it's just
everywhere.
today.
But you still save time for us, and I thank you so much for that. And as for me, as a businesswoman, also, I would just like to comment on the anti-money laundering question earlier. That is actually a real thing. There's a dirty money watchdog that's based in Paris that actually gray list, not really blacklist, but gray list countries that has no anti-terrorism acts. So they're saying that if we don't pass this law, they will put the Philippines in the gray list. And once we are on the gray list, it will affect some financial transactions, especially with banks and financial institutions. So I just wanted that clarified. And I think that is one of the strengths of this bill. If there's a reason to pass this bill, that would be the first one for me. But I also agree with Attorney Chrissy that I think there's something fishy with the timing. That's one. Um, I believe the Create bill and the Arise bill deserve to be prioritized more because they will answer the health and economic crisis that we are facing right now. And everybody is suffering from it in all social status. With all social status, everybody from the poor to the rich are suffering now because of this pandemic. And I think there are other bills that could have been prioritized. And two, I've traveled a lot, and I Dean Peng mentioned earlier that in Singapore, for example, and in other countries, they have very strict anti-terrorism laws. You can see that they when you ride the train, there are anti-terrorist videos. So they're really very strict. But I think that has a lot to do with public trust. If the public has or trust the government will not abuse a certain law, then there's really no problem. So I think now the government has to address that. I know the surveys are saying something else. They said, but just earlier today in some of the chat groups I'm a member of, a lot of people are already saying to erase their comments. They're afraid to comment on certain things. So it's really real. That chilling effect is real. As a netizen, I can really attest to that. So I believe there is still a lot more to be reviewed. when it comes to the Anti-Terrorism Act. And if there's a group of lawyers that's going to the Supreme Court to question the provisions, I think that's a good thing. But I do agree that there is a need for an Anti-Terrorism Act to counter terrorism. But I like what Attorney Christie said earlier, that it has to be something against the terrorists, not against the general public, or not something that the general public will be afraid of. So there you go. Thank you, Roma, and thank you again to all our guests.
Thank you so much, Ms. Florence. Well, a lot of fears are really arising from this law, but we really need to understand and read about the anti-terrorism law. This is really a very controversial but a very meaningful discussion today, and we hope you learn as much as we did from our speakers. Well, thank you so much to our guests for today and to everyone who joined us, including, of course, our technical staff and, of course, everyone who is here right now in Grandline Studio. This will not be possible without each of you, and we're looking forward to seeing you again to our next online salon. Thank you so much for watching us. Please don't forget to leave a comment, like, and share our Facebook page, and make sure to subscribe to our YouTube channel, GLCA TV. And in our next program, let's have our thought of the day. Miss Florence.
All right, so our thought of the day from Joichi Ito, a Japanese entrepreneur. He said, if we destroy human rights and rule of law in response to terrorism, they have won. So again, this is Florence.
And this is Roma. For now, stay safe, everyone.